Welcome to the latest episode of International Law Chats, or ILC for short, a podcast from the American branch of the International Law Association. The podcast airs on the first Monday of every month, and we hope you can join us each month for a new episode. I'm Milena Sterio, a professor of international law at Cleveland State University College of Law, and also managing director at the Public International Law and Policy Group.
And I'm Chiara Giorgetti, a professor of international law at Richmond Law School and a non-resident faculty at the Vienna Diplomatic Academy.
We're delighted to welcome our listeners to a new episode of our podcast, where we'll be in dialogue with Harold Hongju Koh, Sterling Professor of International Law at Yale Law School. Professor Koh is one of the country's leading experts in public and private international law, national security law, and human rights. He first began teaching at Yale Law School in 1985 and also served as its 15th dean from 2004 until 2009. From 2009 to 2013, he joined the State Department as legal advisor, service for which he received the Secretary of State's Distinguished Service Award. Professor Koh has also served from 1998 to 2001 as U.S. Assistant Secretary of State for Democracy, Human Rights, and Labor at the U.S. State Department. Professor Koh has received 18 honorary degrees and more than 30 awards for his human rights work. He has co-authored or authored 9 books, including The National Security Constitution in the 21st Century. He has also published more than 200 articles, testified regularly before Congress, and litigated numerous cases involving international law issues in both the United States and international tribunals. He's a fellow of the American Philosophical Society and the American Academy of Arts and Sciences, an honorary fellow of Magdalen College at Oxford, and a member of the Council of the American Law Institute. He holds a BA degree from Harvard College and BA and MA degrees from Oxford University, where he was a Marshall Scholar. He earned his JD from Harvard Law School. Before coming to Yale, he served as law clerk for Justice Harry Blackmun of the United States Supreme Court, and also Judge Malcolm Richard Wilkie of the U.S. Court of Appeals for the D.C. Circuit. He also worked as an attorney in private practice in Washington, D.C., and served as an attorney advisor for the Office of Legal Counsel at the U.S. Department of Justice. Welcome, Harold, and thank you for being with us today.
My pleasure.
Now, let me begin with the following question. In light of recent events such as Venezuela and Greenland, many fear that the post-World War II international legal order has been undermined and perhaps even jeopardized. What are your thoughts about this? Do you think that our UN charter-based international legal order will survive?
Yes, I do. I'm an optimist, and I acknowledge that this is a very harsh time. But I think that we have been proceeding since World War II and the creation of the UN under a model that could be called Kantian global governance, which is liberal democracies cooperating in international settings, inside and outside international institutions, to attack common global problems. And the U.S. has been a leader. There's always been a counter paradigm to that, which is could be described as Orwellian spheres of influence from 1984. Namely, in each zone, there is a hegemon that does what it can, and the weak suffer what they must, as Thucydides said. And certainly when you have Putin, Xi Jinping, and Trump, it starts to look more like the Orwellian paradigm than the classic Kantian framework. But I think that there's a third way that's emerging, which was defined most recently by the Canadian Prime Minister, Mark Carney, at a speech at Davos, which he called, values-based realism, not naive multilateralism, he said, but building coalitions that work issue by issue with partners who share common ground to act together through a dense web of transnational connections. And he said this is the third path with impact, not just giving into great power, rivalry, or competing for the favor of these greater nations. Now, he described this as a third way, but I think it's really an evolution of the first way. I think it's a way in which those countries he called middle powers step up and assert their values against leading hard power countries. Um, and I think that it's one that then forces the bigger countries eventually back into line.
Thank you, Harold. This is very interesting. I also listened to Mark Carney's speech with a great interest, and this idea of that we are in the midst of rupture, but where mid-level countries should kind of get together. Now, more specifically on one of your roles, because you served as a State Department's legal advisor, and this is really very much of a leading role, and in that you participated in shaping U.S. foreign policy, U.S. relation with other states, international organizations, and non-state entities. In the midst of this change now, how do you perceive the role of the United States in the global relations today? Do you think there's been any changes in the role of the US, but also other superpowers such as Russia, China, and how they play in the world arena?
Well, this is a tragic time. I think we have the worst president in American history. And not only that, he's a person with no respect for law, with no respect for multilateralism, and who, to my deeper concern, is increasingly militaristic. In his first term, Trump did not undertake these kinds of military escapades, but just in this second term, he has done dropping bunker buster bombs in Iran, killing people in Yemen and Syria and Iraq. He's brought the military home to U.S. cities, including most recently Minneapolis. And then this decision, I think, pivotal in its folly to intercede in Venezuela. I can say more about this, but I think this is Trump's Waterloo. It's where his hubris overwhelmed him. But I think we shouldn't ignore the fact that what he's really done is make America an entity that does not lead, and it doesn't follow either. America first means America alone, and other countries are just working around the United States or trying to fill frameworks that the United States claims to create with content. A good example is Russia, Ukraine. Trump proposed simply a framework with Putin, but it's an empty framework. The only substance in it is some things that will pay off various friends. But the Europeans, instead of just standing for just peace, want a just peace, and have forced it into now a framework of trilateral negotiations, and trying to put accountability, compensation, protection for security guarantees for the Ukrainians, and then Ukrainian participation in the negotiation at the heart of it. So I think what we're facing now, and this is a good example, is the Europeans and the Canadians and the like-mindeds filling this empty framework with human rights and rule of law content, injecting humanity into a naked process. And Trump, doesn't care. He wants to claim success and then somehow claim that it's due to his own peacemaking. But his kind of peacemaking is entirely transactional. It's peacemaking without follow through. And so I think that in many different institutions, the United States is doing what I call resigning without leaving. They claim to exit, and then they're still there, but they're lame ducks, and nobody listens to them. And they have no say in some of the things that are of great importance to the American people, like public health, like climate change, so many other things.
Now, in light of these comments, Harold, about the expanded powers of the president, I wanted to ask you a specific question about your recent book. So back in 1990, you had published the National Security Constitution, Sharing Power After the Iran-Contra Affair, but then you published what I would call a revised, updated version in 2024, the National Security Constitution in the 21st Century. And in this book, you argue that the U.S. constitutional system of checks and balances is under attack in light of executive unilateralism assisted by congressional passivity and judicial tolerance. And it can be argued that recent events such as Venezuela and Greenland and perhaps others underscore your argument even further. Do you think that the presidential powers in the realm of foreign affairs has been expanded too far? And if so, and perhaps most importantly, what do you think can be done about this?
Yes, and thank you for your own contributions in this area, Milena. You know, sometimes you write a book and people don't listen, so you have to write it again. The irony of this book was when I set out to do it, I thought that Joe Biden would be reelected president, or maybe Kamala Harris. And what I noticed was from my time in the government, from one administration to the next, the president was just asserting more unilateral power, sometimes proactively, sometimes reactively. But whatever happened, the pendulum kept moving more and more toward presidential power. And this was particularly fueled in the 21st century after 9/11, when Congress just poured money into the defense and intelligence apparatus. And I witnessed this personally because I went into the government 4 different times. Each time, the executive was more and more dominant. Law was less and less important, and Congress and the courts were just irrelevant. So, a good example was I used to attend meetings in the 80s when I was in the Reagan administration, where there would be one lawyer from state, one lawyer from justice, one lawyer from the Defense Department, and one lawyer from the CIA. When I came back, particularly in Joe Biden's presidency, fall of 2021, there would be one lawyer from state, one lawyer from justice, and then 20 lawyers from the Defense Department, as if one muscle was being given steroids. And these people had infinite resources, and they only valued their own power, their own capability. So, as I say, if all you have is a hammer, everything looks like a nail. The emphasis was on kinetic force. I thought this was an extremely dangerous trend, and I thought that Democrats in particular would not point this out if a Democratic president was elected. And very often the Democrat had to act unilaterally in their view because their legislative majorities were so slim. Anyway, the election of Trump, the second election, which surprised me, I don't have to tell people anymore this is a problem. But there's an irony here, Milena and Chiara, which is, and it's a partial mea culpa. When you're a lawyer in the government, you understandably say we must protect the world from national security threats and Americans from national security threats. And the way you do it is you give the president the benefit of the doubt on legal arguments, because you think that the best protection against a national security threat is more presidential freedom to respond. But then when you add up thousands and thousands of these decisions, you have the president less and less constrained. And what it does not account for is the idea that the president himself becomes the most severe national security threat. And he is essentially unconstrained by the work that you have done. And so you've helped to create a Frankenstein monster. And so that was part of what I was suggesting. Now, in the book, and I won't bore people with it, toward the end, I just tried to give very detailed institutional responses, because this was the key point. This is a structural problem. It's obviously Trump is an aberrational person and an aberrational presidency, but nevertheless, the problem is structural. It happens with Democrats and Republicans alike. So you need structural fixes, and I suggest a huge body of them. But for now, part of the problem is resisting Trump and making sure he doesn't destroy the system. So I think we have an additional set of steps. We need to engage in resistance, resilience, and then reform and reconstruction. And those steps will take many years to get to the kind of more stable legal order that we all aspire to and think ought to be the purpose of a more perfect union.
Thank you. Indeed, one of the surprising issues that actually in terms of the unconstrained precedences that you mentioned is the declaration by Trump in one of his interviews that he feels unconstrained, that his only guidance would be his morality rather than international law, which I found quite worrying. But in terms of the going back to your specific issues of like what you're suggesting, and in the National Security Constitution in the 21st century, you discuss specifically treaties also. And you propose that the treaty exit mechanism should mirror somehow the way that the treaty was entered into. Like, in light of the Trump administration recent announcement that the US would withdraw from the WHO, but also in light of other Trump's administration's international agreement withdrawals, including on climate change and the most recent ones announced in terms of international organizations. Can you tell us more about this idea in terms of treaty exit mechanisms and why do you think this is important?
Yeah, so, you said two things, both important, Chiara. First, Trump says his only constraint is his own morality. That's not true. His constraint is his oath. He only has the power that comes to him from the Constitution. And the Constitution eliminated a king. He was not a king. He had limited executive power, broad power, but limited, and that power is expanded over time. So if he's getting his power from the Constitution, and the 9 times I took the oath of office, I never took an oath to serve a particular person. I took an oath to uphold the Constitution and laws of the United States. So, within seconds after he became the president, he broke that oath. He said that birthright citizens are no longer citizens. That's unconstitutional. So obviously that oath means little to him, which means that others have to enforce it on him. The second point, I think, is that you've made about the World Health Organization just illustrates a number of the points I've already made. And here's another example where scholars have contributed to the problem, I'm sad to say. In the late 70s, early 80s, arose a sort of conventional wisdom that the president had the unilateral power to terminate treaties. And it arose out of the Goldwater versus Carter case, where President Carter terminated a bilateral treaty with Taiwan in accordance with its terms and consistently with international law, because the United States was recognizing Beijing as the capital. Now, there was a lawsuit by Senator Barry Goldwater, but it was found to be non-justiciable. But there was no ruling on the merits, which when I was in the government, executive branch lawyers took it to mean, okay, if the president terminates every treaty or every agreement unilaterally, no one will be able to sue us. Now, since then, the law has changed. The Supreme Court has been much more questioning about the political question doctrine. There are ways to get standing that didn't exist before. And so the real question we should be asking is there a one-size-fit-all exit mechanism where the president could Donald Trump today tweet, I withdraw from every treaty the United States is a party to, including the UN Charter. Now, the WHO is a good example. One size doesn't fit all, in that not every treaty is entered the same way, so not every treaty can be exited the same way. And in fact, the WHO has a provision that says that you must pay. You can withdraw after 1 year. This is in the Congress passed a law in 1947 when the U.S. entered the WHO, which you shall meet the contributions and dues that are owed for the current fiscal year, which for the United States right now is $200 billion. When you put together current past dues and owed for this year, Trump is not going to pay that money. So, in law, contract law, this is a legally binding condition precedent to exit from the agreement, and it has not been satisfied. So the U.S. has not exited as a matter of domestic or international law. In other words, we're there. We've resigned, but not left. That's resigning without leaving. So, of course, no one will listen to us in the WHO. but we have no freedom because we're still a part of it. And this raises a broader question. What if Congress passes a law like the No NATO Withdrawal Act, which says you can't withdraw from NATO without congressional approval? Does that mean that the default rule is that you can withdraw? And that's where, again, Goldwater has been wildly overread. The fact that there are treaties or agreements that mean nothing or that nobody contests doesn't mean that the president and Congress and the courts agree that he can withdraw from any treaty. The more logical idea is that there should be a mirror principle. The amount of congressional input to enter should be roughly comparable to the amount needed to exit. Now, this turns out to be the rule in many, many countries. This is, for example, the basis for the Brexit decision in the UK. Obviously, some international obligation that entails so many domestic implications should not be done by one person acting alone. And I believe that this issue will be litigated with regard to the WHO. After all, another condition which even the Trump administration respects is that you give notice, but you have to wait a year to withdraw. So it takes a year, and then you have to pay the dues. And he's not going to do that. So all you need is a court order saying, as a declaratory judgment, the U.S. is still in. And that will help to clarify this issue. A final point is, if the president and Congress pass a statute together, how can the president repeal that statute by himself? And so if the president and the Senate pass a treaty together, or the Senate and the president and Congress pass a congressional executive agreement together, which is like a statute, how can the president unilaterally exit himself? This is not part of the constitutional plan. And I think this is another example of how this tendency to give the president hints of power, which he then extends into massive overreach, in which Congress then becomes too cowardly to resist, and then the courts decline to invalidate, creates the structural problem I was describing in my book. It's a perfect, unfortunate microcosm of the whole set of issues that the book raises.
Thank you, Harold. Now, let me switch gears a little bit and ask you a slightly different question. In addition to everything else, you've also litigated numerous cases, and I know that in the early 90s, you led a group of Yale students in a successful suit against the U.S. government to free Haitian refugees who had qualified for political asylum in the U.S., but had been detained indefinitely in Guantanamo Bay, Cuba. And I also know that you've been involved in human rights litigation with some of your Yale students more recently. What do you think is the importance of litigating these cases, not just for the individual litigants, but also for the protection of human rights more generally speaking?
My brothers are doctors, and my father was an international lawyer and a diplomat in Korea. And when my brothers got their medical degrees, he said to them, until you became MDs, you had no moral obligation to heal sick people because you didn't know how. He said, but now you have this knowledge. You can't just know it. You have to use it to address the problems of the world. This is not a self-correcting system. It requires human agency. And he said to me, when I got my law degree, until you understood how the body politic works, you didn't have any moral obligation to try to enforce the rule of law. But the rule of law is why you are who you are. I'm a birthright citizen. My parents came as refugees. If I'm not, I'm lucky to have a tenured position at a law school. If I'm not going to fight for these rights, who will? And it turns out many of my students feel the same. I also think, just as a general matter, that theorizing alone is not enough. And another thing my father would always say is, theory without practice is as lifeless as practice without theory is thoughtless. And one thing I noticed when I was studying international law as a student is, if all you do is pick a number of isolated incidents and analyze the legal issues in them, that's helpful. But it doesn't tell you how to make the world better. And in the faculty lounge, you're never wrong. If you make a mistake, get another cookie. But in the real world, if you make a mistake, people die. And this is a very serious thing. And so you can't just sit around and say, Trump is destroying the world. What are we going to do about it? My teacher likes to tell a story about how someone fell in the subway, and a lady who's standing there says, somebody better call somebody. You're it. You have to appoint yourself. And so we have now a rule of law clinic at Yale Law School. It existed in the first Trump administration. It now has about 45 students, 6 faculty members, and we're working full time. We're litigating and participating in about 50 different cases to try to support the rule of law in many manifestations. And I've done this 4 times before. At the same time, on the international level, I'm, representing Ukraine and a number of other countries before international courts. Again, trying to use what I call transnational legal process to promote the rule of law. And this is finally what I would call the Yale School of International Law. Chiara's professor and my friend Michael Reisman and Myers McDougall talked about world public order of human dignity. And what that means is that the system of international law is designed not just to be an academic legal discipline to be studied. It should be something that actually promotes a order based on a more humane process of globalization. And those in the school, and I count Chiara because she's a graduate of the Milena, I count you too as a fellow member of the school because of the work that you do. We believe in international law. We believe that the U.S. is imperfect, very imperfect, but can contribute. And if we have a capacity to influence the system to move in a more or less humane system, we have a moral obligation to pursue that. And, after a while, you start to believe that that's your calling. You don't just go into a line of work just to earn a paycheck. It has to be a reason that you were put on the planet. My old professor, Abe Shays, said once, he sued the United States. He was legal advisor of the State Department. He sued the United States on behalf of Nicaragua. And they said to him, aren't you a traitor because you sued Nicaragua? You sued for Nicaragua against the United States. And he said, I've always thought that there's nothing wrong with an American lawyer holding his or her country to its own highest standards and principles, inside or outside the government. And that's been one of my mottos as well. If I can do it by being inside, I do it by being inside. If I can do it by being outside, I do it by being outside. If I do it by scholarship or by talking to people, as on this chat, or if I can do it by participating in litigation or domestic international law, I'm at a lucky stage of my life, which is, I've seen a lot. And, this is what doctors do. They try to work on the toughest cases and to try to make a difference. I'm I'm a lucky person. I'm a lucky person, and that luck should not all be for me.
Thank you. Well, it's an honor to be part of that school, and in fact, I had the great honor to have you as one of my JSD supervisors, as you just mentioned, at Yale School. I'm forever grateful for that and the experience to study at Yale. And I know very well that at Yale, but everywhere, you're known as a scholar practitioner, right? You are distinguished. You have a very distinguished academic career. but you also had prominent government position and where you were able to practice international law on behalf of the U.S. government. In addition, you litigated many cases, both in U.S. courts and in international courts. My question is this: how do you balance? How are you able to balance all these roles? I agree that you have, as a lawyer, maybe a duty to do all that, but in terms of in practice, how do you unify all this thread in terms of what inspires you and how you have approached these different roles and engagements in your career?
Well, I met Jimmy Carter before he died a couple times, and he said something that just he said, my wife and I wake up every day and ask, how do I make the world better? And I thought, well, that sounds on the one hand naive and idealistic, but on the other hand, that's not a bad way to think about it. And I asked another person who is a distinguished politician, but also a scholar, how do you make things better? And he said, when the urge to act is greater than the urge to write, I act. And when the urge to write is greater than the urge to act, I write. Now, when I was a student, this is sort of where it came from. I was taking a class in college, and they started talking about what they called scholar diplomats. And I said, what is that? And they said, well, Henry Kissinger, John Kenneth Galbraith, Daniel Patrick Moynihan, these are people who wrote important books, but they also practiced. They moved in and out of government. It's very difficult to work in government. It's so grueling. But on the other hand, when you talk about what you're doing, people know that you know what you're talking about. It's not just spectating from afar. I often hear in academic discourse criticism of governmental policies, and then they say, our conclusion is that the people who did these policies are stupid. But they're not stupid. They're just as smart as the people in the academy. They're just operating against real world constraints. And so I asked those people, what would you do instead that's better? This very simple question, what would you do instead that's better? And the number of times that they can't answer that question. I'm very good at criticizing. I'm very good at deconstructing, but I'm not good at coming up with an alternative solution. And I think that's half the analysis. You have to be able to say what you would do instead that's better. And, a good example was, did the United States illegally invade Iraq? Yes. Was that a tragic mistake? Yes. But when I got into the government of the Obama administration, the United States is in Iraq. So the question is, how do you exit this situation? You can't go backwards. And the academic analysis was, well, we made a mistake way back when, too bad. That doesn't get you into the future in a better way. So you have to figure out a way to chart your way back to where the world should be. And we're in the same situation with regard to Trump. Is it unfortunate that this unqualified and lawless person was elected president? Yes, it's deeply unfortunate. And is it unfortunate and tragic that he was reelected? Yes. But, he's already starting to collapse. And so the question is, how do we build back a better system? How do we move from resistance to resilience to reform to reconstruction? That's the goal of the Yale School. How do we build the world public order with human dignity using transnational legal process?
Thank you, Harold, for this very powerful and thoughtful remarks. And so to wrap things up, really huge thanks to Professor Harold Koh for being our guest today and sharing his thoughts with us. Thank you also to Freya for all her work editing and organizing the podcast. I've really enjoyed our conversation, and if our listeners have too, you can join us on the first Monday of every month for more international law chats.